My lords, my lady, with the court's indulgence, there's just one point that I wanted to mention briefly, which came out of my review of yesterday's transcript. I think there may have been one point of principle on treaty interpretation on which there may have been some confusion, and that concerns the question of when Article 32 supplementary materials may be referred to. Article 32 is at LA 30, page 3, and the text makes clear that there are two possibilities. Where there is an ambiguity or a manifestly absurd result, supplementary materials may be used to determine the meaning. The exercise of determining the meaning of the provision in that it is otherwise absurd would often require implying terms, and this was the point that Lord Verderame was making to you in the second appeal. But also, where there is no ambiguity, supplementary materials may still be used to confirm the meaning resulting from the application of Article 31. And supplementary means is a broad term, as we've discussed. It's not limited to preparatory works, and it may include consideration of other treaties. That's the only point I wish to make. Thank you.
Okay, thank you. Yes, Mr. Richards.
Hello, my lady. I was running through the annex yesterday afternoon under the headline of addressing the agency point. That was the second of the points that the Czech Republic raises on this second limit of its appeal. Overnight, having considered this further, it seems to me that the exercise that I'm undertaking and will be going through during the course of this morning is in fact relevant to all parts of their de facto assessment appeal. So what I'm going to do is complete this exercise, and then I'll turn to, actually relatively briefly, the 3 points that they make, a more efficient way of doing it. So I was explaining that the law book transaction comprised the whole, all of those 6 items that the judge had identified. And that included the settling of the shares into the trust. And I just had some brief points on this before we move on. The point made against me is that there is a divide between the sale and the settlement of the shares, and that Mr. Stava didn't have to take the step of settling the shares. Our answer is simply this. The Minister and the Prime Minister, as Mr. Stava's evidence set out, asked him to take steps to distance himself from Diag Human. He did that, and they cannot now say, well, we didn't mean you to do it in that way. And the fact is, we say, that the events of 2011 occurred because of what they encouraged. Now, moreover, and this is a point that the judge found relevant, they had the opportunity to address this in evidence before the judge, but as the judge found, they chose not to do so. And for reference, we don't need to go there. That is, we will be looking at what the judge said. In fact, we can pull that up because we're going to be carrying on in Annex 3. That is Core Bundle 23, tab 23, page 99. All I'm going to do is just give you the reference to the evidence that he's mentioning. So on that page, page 99 of the Core Bundle, the judge said, paragraph 19.4, so 19 starts on the previous page, and then 4, he just notes the fact that the Czech Republic did not call any evidence to challenge Mr. Stava's account, either in the BIT arbitration or before me. The most detail was set out in the BIT arbitration evidence, and all of that material was admitted into the trial bundle before Mr. Justice Foxton. And the reference for you, as I say, we don't need to go there, is SB Supplementary Bundle, tab 20, page 2. And that's Mr. Stava's third statement in the BIT proceedings. And I would ask you, when you come to that, to read paragraphs 7 to 16, where Mr. Stava sets out his evidence that he entered into the entire suite of agreements, including those concerning the Corona Trust, as he says, quote, solely to facilitate settlement, unquote. The judge has found in our favour on the fact that the law book transaction was pursuant to the encouragement of the Czech Republic. And we do raise this as an additional reason in our respondent's notice, point E, as to why the judge's decision should be upheld. It is a new point, as the Czech Republic indeed agrees, though I note that our respondent's notice doesn't actually say it's a new point, but it is. So that's all I wanted to say on that. Just while we're on this area and the setting up of the Corona Trust,
succession planning and so on. My learned friend made some comments in relation to succession planning about mandatory heirship and tax law as a matter of Liechtenstein law. I should briefly just say, to be clear, neither concept was addressed by either of the Liechtenstein law experts in their reports, and they were not on the expert list of issues. The points emerged for the first time at trial during my learned friend Mr. Dunning's cross-examination of the Liechtenstein law experts, and hence they're not dealt with at all in the judgment. And they're not open, if any reliance is to be placed on those submissions, they're not open as points that the Czech Republic can run in this appeal. And the court should proceed on the basis that what my learned friend says about Liechtenstein inheritance law and trust law is very much in dispute, and that there have been no findings on them in any event, nor any...
There is a finding that Mr. Staver's purpose was succession planning in relation to the trust.
And that's as far as it goes.
As I understood Mr. Dunning, he was explaining what that means in circumstances in which it might be thought that there weren't any tax implications for him. It was still a finding that made sense.
All I'm saying, my lord, is that insofar as it goes beyond the finding that is made in the judgment, that's not open to them. I understand your lordship's point that understanding my learned friend as trying to explain what that was, insofar as that is seeking to make points which do not arise out of the evidence that was before the judge, we would say that that's not open.
What's your point? Why does this matter?
Well, indeed, insofar as my learned friend was trying to say that there was, you can read something more into the finding of succession planning beyond the obvious idea that it's about your heirs and successors taking the benefit of some assets, that is not something that is open to them to run. Indeed, if we look at paragraph 20 of Annex 3, the judge noted about 2/3 of the way down the paragraph that he also accepted that asset protection may have been a reason why this asset was, which by this point had a controversial and troubled history in which the resources of the Czech state have been deployed to a striking degree in an attempt to prevent the realization of any value, appears in a discretionary trust essentially on its own. That's all I need to say on that, my lord.
But Mr. Staver obviously wanted the Corona Trust arrangements to continue and to be valid under Liechtenstein law at a time when he knew that the original purpose of the law book transaction had failed. He could simply have, on your case where he had control of everything, he could simply have diverted all the shares back to him if he'd wanted that structure. It was his choice to leave things as they were.
Two answers to that, my lord. One is this was all structured, one has to take it as this was all being structured in 27th of May 2011. So we take it on that basis. And secondly, if one then starts to speculate about what may have been going through Mr. Staver's mind thereafter, that is then beyond the relevant date of assessment that the judge decided we should look at, namely midnight on the 31st of December. So one is constrained in looking at essentially the automatic functioning of what was set up on the 27th of May 2011. We can speculate as to what might have happened in 2012 or 2013 when Mr. Staver thought, well, now what's going to happen? But that's not actually the relevant purpose here. And even if we were to go into that, my lord, there is, we would submit, merit in the point that the fact that the shares are located in that trust structure at that date is, without doubt, in part at least, pursuant to the encouragement of the Czech Republic. And that's really, I'm not trying to go beyond that, but that's all I say on that. So continuing in Annex 3, and I'm on page 99 of the core bundle now, The judge then went on to analyse the Karuna Trust deed itself. And over the page, he then identified that Mr. Starver was a settlor. We've seen that. We also see with Mr. Starver as a protector, this is in Roman numeral 1, the protector was entitled to nominate a person who would become protector once they ceased to hold that office. So if Mr. Starver took steps which took him out of the role of protector, the most obvious one being if he decided to become the trustee himself, or for whatever reason decided to step away, he of course had the control over who the person would be who would replace him. Then we see that in 2, the trustee as the trustee, then it goes on, the protector had the power to appoint new or additional trustees or remove any trustee with the prior written consent of at least 3 persons qualifying as beneficiaries. There was a debate about whether that meant, and in the event we are talking about the daughters and Mr. Starver as the beneficiaries, there was a debate about whether that meant Mr. Starver and 3 daughters, or Mr. Starver as a beneficiary qualifying for the purpose of providing consent, plus 2 daughters, so that you meet the requisite 3. And the judge concluded, having heard evidence from both of the Liechtenstein law experts, that the better answer was Mr. Starver plus 2. So in other words, if Mr. Starver wanted to appoint a trustee or replace the trustee, he needed the consent of only 2 daughters. We'll come to that a little bit more later on. So we see that the trustee then also in 3 we have it's identifying the class of beneficiaries. Then we have 24, the trustee relieve the trustee of various default obligations. The point being, the overall thrust of this was that there were a number of functions that a trustee might have performed which didn't in fact fall to this trustee in this case on this trustee because of the decision of the settlor, Mr. Starver, that it would be structured in a way that effectively a number of the powers either were not, or a number of the obligations were either not imposed on the trustee, or a number of the powers were delegated from the trustee to him, to Mr. Starver. And we can see in particular that over the page on 24 Roman 9, wide administrative powers, including to delegate powers and discretions to managers or advisors, or to use nominees, or to delegate any of their powers on such terms as they saw fit. And there are references throughout here to the trust deed itself. I'll just give you the reference for that. We don't need to go there. But when you're looking through this, if you want to see the source of these findings, that's at Supplemental Bundle 18. And just to check, I'm pretty sure that should be in your hard copy bundles. Yes, it is. So, sorry, I've given you the wrong reference. Someone will give me the better reference. Thank you. Sorry? SB 48. We don't need to go there. Then we have 25, similar thrust. The trustee shall not be required under clause 24 to interfere in the management or conduct of the business of any company. And then we can go on to 29, and we're now in the applicable principles of Liechtenstein law. And the judge set out matters that were common ground between the experts, which included that the trustee was obliged to comply with the trust deed and owe a duty to manage the trust property with the diligence of a prudent businessman, and a fiduciary duty of loyalty to act in what the trustee considers to be the best interest of the trust. And then relevantly, in addition to that, 3 over the page 102, the same duties are owed by a protector of the trust who cannot hold the trust assets in the trustee's place or deal with third parties in relation to the trust assets by virtue of the office of protector alone. Then, just going on down to,
Could you read the next in brackets?
sorry?
Could you read in brackets?
Yes, as opposed to when acting on behalf of the trustee. Yes, I mean, the point, the relevant point is that when the protector's acting pursuant to his protector powers, he owes the same duties as the trustee identified in Roman 1. And then at 8, a settlor or beneficiary who consents expressly or tacitly to a specific act in apparent violation of the trustee's duties is barred from raising a claim about it thereafter. And if all potential claimants consent and no creditor is harmed, a subsequent trustee will not be able to bring a claim. And that arose out of a debate about what would happen if the trustee or Mr. Stava in the position of trustee or indeed in the position of protector decided to take a step. And subsequently it was held, or someone considered that it wasn't in the best interest of the trust. The point was, if at the time it was taken, all of the beneficiaries consented, those beneficiaries would not be able to bring a claim subsequently. There would not indeed, Mr. Justice Foxton found, even be a breach. It wouldn't just be a matter that they wouldn't have standing, but the trustee himself wouldn't be in breach. Then we have 9, Roman 9. The beneficiaries or class of potential beneficiaries do not have any property rights with regard to the trust property, and the judge makes the point that Liechtenstein law recognises no concept of equitable property. We don't shy away from that. They do, in the middle of that paragraph, have the right to demand the trustee faithfully execute the terms of the trust and diligently conduct its business. And then there's a route for them to go to court and seek relief through the court. Then the judge turned to matters on which the experts were not agreed. 31, he dealt with the point which, at the end of 31, we can see he concludes it's not necessary for him to decide, and that relates to paragraph 218 of the judgment, whether there's some inconsistency in terms of trying to assert a position that's inconsistent with Liechtenstein law, and the judge considered that that didn't arise in this context in respect of there being a mutual understanding whereby the trustee would always follow blindly Mr. Stava's instructions. As he said, that didn't arise. And then 32, there's an issue as to whether a protector who is also a beneficiary could exercise the power to remove the existing trustee and or appoint himself as trustee and distribute trust property to himself. And the short answer is yes. And then we look at 1 and 2. The protector's exercise of his power of appointment or removal will be subject to the duties in 29.3, and 29.3, of course, was the provision providing that the protector is subject to the same duties as the trustee. And then we have 2. However, in principle, someone with a power to remove the trustee can appoint themselves as replacement trustee. And the mere fact that the decision to remove the trustee was taken with a view to appointing the protector as trustee would not involve a breach if the powers were nonetheless exercised in accordance with the general duties. In other words, just because Mr. Stava planned to put himself in the place of the trustee or put a nominee company, Liechtenstein company of his in the place of the trustee, that didn't somehow mean that it was a breach of duty on his part as protector to remove the trustee. So, pulling some of those points together, Mr. Stava had the power, if he decided it was in the best interest of the trust, that he to replace the trustee with the consent of 2 daughters. And by that route, he could put himself in the position that the Czech Republic considers is the person with control. And as I'll see further on in the annex, the judge found that Mr. Stava was peculiarly knowledgeable and well placed in respect of the business of the trust, or of Diag Human, the only asset in the trust. So on the facts, it would have been entirely consistent with Liechtenstein law, and we say within the four corners of the trust, for Mr. Stava to do this. Then we go on to 33. Just to point out, Roman 3 addresses the point that I've already explained about whether you need 3 daughters in addition to Mr. Stava consenting, or just 2, and the answer was 2. Then we have 33. This addresses the ability for Mr. Stava to make distributions to himself if he did appoint himself or his nominee as a trustee. And that's obviously an additional point. So you have 2 stages. Question of whether you can put yourself in the position of the trustee if you're the protector. Answer yes, so long as it's in the best interest of the trust and you have the consent of the 2 daughters. And then additionally, once you're in that position, can you make distributions to yourself? Again, answer yes, with so long as in the best interest of the trust and with the requisite 2-daughter consent. Then 34 to 44, this addresses the point that we sought to raise at trial, and I will make some observations on it very shortly, about whether we could run a point that control could also be derived, requisite control for the purpose of the treaty, could also be derived from the daughter's nationality on the basis that they were all Swiss. Now, the judge held against us there, and we see his conclusion at 44. The ultimate point, as he says in the final sentence, that it was sufficient to dispose of the points on his analysis, but I would in any event have held it that it was not open to the arbitral claimants to advance it against the procedural backgrounds we've outlined, namely that he concluded it wasn't in our pleading. So that was the point there. Then we move, and then this is really the critical part of this document. The heading on page 108, just above paragraph 45, is Mr. Stava's ability to influence Diag SE's actions and decisions. And the first of those headings is the control of the legal rights, which were Diag SE's only assets. Flicking forward to page 110.
Sorry, I thought you said that paragraphs up to 44 deal with the point about the nationality of the daughters. I thought they were dealing with a different point, which is that Mr. Stava was the holder of the bearer shares, to which the judge's answer was that he held them on behalf of the trust. I can't see anything
Yes,
about that.
my lord, I'm talking. You're absolutely right, my lord. Sorry, my notes have confused me. That is correct. That was the point that I've just got the page wrong. That was the point again that was not pleaded. That's the
Sorry, which was the point that was not
yes,
pleaded?
I apologise, my lord. I've been confusing the court there. So there was a point that came out of the cross-examination of the experts, in particular Mr. Reitner, where, well, indeed, it came out of his report, his original report, where he, his evidence, his opinion was that if you hold the bearer shares as a matter of Liechtenstein law, that means you're the owner. Now,
Yes, I understand that point, and the judge decides that against you.
Yes, and in part because we didn't plead it.
So it came at. Well, he also decides it on the merits
He
against
does.
you.
That's why I said. But I mean, that was his in any event.
Yeah.
Yes. But he decides that against us, and we do not seek to challenge that conclusion. Where that ends up, and sorry, my lord, the reason we don't rely on, or we don't seek to challenge that, or why I didn't go through that, is because it's not relevant here. Because before this court, we accept that Mr. Stava holds the bearer shares as agent.
Yes.
That's where we are. So, and that is indeed the point that is made against me, that insofar as Mr. Stava has rights that derive from holding the bearer shares, namely the right to vote those shares at the company meetings, those are rights that are the rights properly of the trustee.
Yes.
And we accept that. That's
Yes. No, I only interrupted because you made a point about the daughter's
I
nationality,
did.
which I hadn't seen in Annex 3. It may be that we're coming to it, but
yes.
at the moment I
No,
haven't seen it.
I'm sorry, my lord. It's the way it was. It was probably a moment late in the night where I was
All right.
restructuring my submissions, and I put the paragraph in the wrong place. But that is absolutely right, and I apologise for misleading the court on that. But hopefully that's clarified the point. But it does. The points don't arise because, as I say, we accept that he holds the rights that derive from those shares as an agent on behalf of the trustee. Then, as I say, we move on to the analysis of the ability, Mr. Stava's ability to influence Diag's actions and decisions. And the first heading is control of the legal rights, which were Diag's only assets. Then on page 110, we have just the headings. I'm just looking at the headings for orient the court, the management of Diag SE, and then finally the operation of the Karuna Trust. So just going back to 108. So we have, for the rest of this document, the judge's assessment in that Liechtenstein law context that he set out of Mr. Stava's ability to influence the Diag's actions and decisions. Now, first, controlling the legal rights, which are Diag's only assets. The relevant point to note here is that at 45.3, that Diag's only assets, it's just in the first sentence of 45.3, its only assets of any substance were the legal claims it had arising from events while it was still trading, in particular the final award, the enforcement of which was facing strong and generally effective resistance by the Czech Republic. Then we have 46. When settled into the Karuna Trust, therefore, as the Czech Republic stated, Diag had no business other than seeking to recover under its commercial arbitration award. I accept that it was Mr. Stava who was in de facto control of that process. He was the only person with first-hand knowledge of the relevant events, not LNR Trust, nor Dr. Rabanza. It was Mr. Stava who was the sole source of funding for the litigation. Then he sets out various statements which go to this issue, but really one can reach the conclusion by moving to the last sentence of this paragraph, where Mr. Justice Foxton found that Mr. Bridson was a solicitor providing a witness statement to the High Court on behalf of the Czech Republic. Mr. Bridson's description of Mr. Stava as the guiding hand and financial force behind Diag SE was accurate. And just pausing there, it's worth remarking that, of course, the power or ability of Mr. Stava to fund Diag Human was not something that he held on behalf of anyone else. That was him, effectively outside the trust structure in his own capacity, deciding to put more assets in the form of money into the trust structure, and that was something that exclusively lay with him. If he decided not to do that, that could stymie or reduce the value of Diag's only business, namely the pursuit of the claims. Then we go on to 47. I accept, therefore, that to all
A Swiss litigation funder, who is the sole source of a claimant's funding for a claim, would not qualify under the BIT, would they?
on that basis alone, I mean, that there are issues that arise in international law about origin of capital, but on that basis alone, it may not. In our case is, of course, always about the cumulative aspect of this, but it depends on the circumstances. But if one were to present that on its own and nothing else, it might be a struggle to make that point good. I'm sure my colleagues will correct me if that's wrong. Paragraph 47, I accept therefore that to all intents and purposes, Mr. Stava had practical control of the pursuit of Diag's only assets, whose pursuit was dependent on funding by him. In seeking to pursue and realise those assets, there was no scope for any conflict between Mr. Stava and the trustee. The interests of Mr. Stava and the Karuna Trust, which he had established, of which he and his daughters and their children were in the class of beneficiaries and into which he had settled Diag, were perfectly aligned in that respect. And just to be precise here, in that respect, I don't want to be said I've overplayed my hand. In that respect is the pursuit and realisation of the assets. Here, of course, we are still under the heading of control of the legal rights, which were Diag's only assets. Nor was there any practical scope for the trustee to second guess Mr. Stava's decisions in the attempt to realise that asset. These matters were peculiarly within Mr. Stava's knowledge and were being funded by assets outside the Karuna Trust. And then paragraph 48, referring to clauses of the trustee that permitted the trustee to act in a way which reflected that alignment of interest. Just as an example, 19.2, you'll recall that was the one that Mr. Justice Foxton earlier on had referred to as the one that permitted the trustee to delegate powers to Mr. Stava. And of course, again, we accept that those powers that he was exercising pursuant to that, namely the right to vote the shares, were powers he was exercising on behalf of the trustee. And then we carry on. The trustee was also entitled, but not obliged, to have regard to the wishes expressed by Mr. Stava as settlor, protector, and as a beneficiary on issues relating to the pursuit of legal claims open to Diag. I am sure that the trustee would have done so, deferring, I do stress that word, deferring to Mr. Stava on matters relating to the pursuit and control of Diag's claims would inevitably comply with the business judgment rule, and as I have stated, there was no meaningful possibility of the trustee forming and seeking to act on a different view to Mr. Stava's claim, Mr. Stava as to how to enforce Diag's claims. And then, an important point, as I say, and we obviously accept this, Mr. Stava was not exercising legal powers of control held by him in his own right. And those powers could not be exercised exclusively in his own interest. The immediate source of those powers was Diag itself. Then we move on to the management of Diag. The judge referred to Mr. Stava as being member of the board and president. Your lordships, your ladyship, you will see some other instances in the documents referring to chairman. It's the same role. That was the term seemed to be used interchangeably. President of Diag and held sole signatory rights. Those rights, again, were in the agency world, were held on behalf of Diag SE, felt to be exercised in the best interest of the company, and in particular its sole shareholder, the Karuna Trust. And then we have the point about the bearer shares. He had the legal right to exercise the voting rights, which attached to those shares in what he believed to be the best interest of the Karuna Trust. The exercise of those voting rights was determinative of decision-making within Diag. The Czech Republic also accepted that independently of the voting rights, Mr. Stava was able to influence Dagmar Stava and Dr. Rabanza, who were two out of the other three members of the board. In our submission, that influence, as the judge noted, was independent of the voting rights. That was influence that he held in his own right. That was something exclusively for him and derived, amongst other things, from his expertise and knowledge, which were unique to him. Where does this go in respect of the management of Diag? The judge referred to the combined effect of the very limited nature of Diag's business, the particular dependence of Diag on Mr. Stava, and the absence of any realistic scope for conflict, meant that Mr. Stava was the determinant voice in all decisions taken by Diag. So that's Diag. Now we move on to the Karuna Trust. The judge found that the trustee had effectively delegated the conduct of Diag's sole business to Mr. Stava, and that was a perfectly proper course. That obviously goes to the question about whether all of this and the judge's conclusions in the judgment were consistent with Liechtenstein law. He held they were, and he was correct to do so, we say. Then 54, trustee of the Karuna Trust had the legal right to sell the shares, where the trustee formed the good faith view that such a sale was in the business interests of the Karuna Trust and represented a prudent business judgment. However, it is virtually inconceivable that the trustee would have concluded that the best interests of the Karuna Trust and prudent business judgment justified such a sale if Mr. Stava was opposed to it. That reflected the fact that Mr. Stava was uniquely placed to assess the value of Diag and how best to realise that value. And then he makes a valid point, which is difficult to see how such a sale would have been a viable business proposition. No buyer would have been interested in this if Mr. Stava wasn't supporting it. So then we move into some important paragraphs. It's really just only 1 page more of this annex, which sets out some critical conclusions. Had the trustee, if we stay on 55 for the moment, had the trustee been intent, we just go back a page, thank you, on pursuing such a sale in defiance of Mr. Stava's wishes, I am satisfied that Mr. Stava's daughters would have, there's no conditionality there, would have supported Mr. Stava in removing the trustee in the exercise of his legal power as protector. And note, just on the agency point, his legal power as protector, there can be no debate that the powers that Mr. Stava held as protector were his own powers. Yes, they had to be exercised in the best interest of the trust, but they were his powers, not on behalf of anybody else. In the exercise of his legal power as protector, to take that course with the requisite beneficiary consent. And then he makes the point that this would have been a means of giving effect to the straightforward business judgment on an issue where his daughters would have deferred to Mr. Stava's judgment. And then third line down on page 50, on page 111, I am also satisfied that in such an eventuality, Mr. Stava would have been entitled properly to exercise his powers to remove the trustee, seeking to effect a sale, and appoint himself as trustee together with a Liechtenstein domiciled trustee. Now, of course, what he does once he's removed the trustee, there were various options, and I don't think it's in dispute. In fact, I think it's common ground that these were all available options. Appoint himself as a trustee. Of course, the difficulty with that is he's then I'll go back a step. The requirement for a Liechtenstein trust is you have to have a Liechtenstein domicile trustee. So if he's going to do it, then he would have to assume Liechtenstein nationality. So on its own, that would not work, because then he's not Swiss. So it's either going to be him plus a Liechtenstein domiciled entity that is nominated, or it's just going to be a Liechtenstein entity that is nominated. Those are the sort of alternatives if he decides to remove the trustee and replace them. Yes, of course. And of course,
And he would then have to have control over the fellow Liechtenstein trust.
indeed. I mean, as I say, nominee. He could appoint a Liechtenstein company, but for the purposes of satisfying the test,
The Liechtenstein
yes,
co-trustee would have its own trust obligations to exercise its own.
indeed. So it's been pointed out to me that the requirement is for the domicile of the entity, of the Liechtenstein entity, to be Liechtenstein. It did not. Yeah. Yes. Yes. Thank you.
Whereas, just remind me where we've got that provision about the nationality or the domicile of the trustee.
So just to frame it, the
Just remind me which part of the deed says that the trustee has to be
I'll
domiciled.
get the reference to that, my lord. Thank you. So then carrying on in 55, he was uniquely placed to administer the Karuna Trust, given its very limited and very particular asset base, and he would have been supported by his daughters in doing so. That situation never came to pass, nor was it ever remotely likely that it would be necessary. 56, in his capacity, this is then addressing the blocking rights. In his capacity as protector, Mr. Stava had the legal power, again his own legal power, to prevent the trustee adding an individual or excluding an individual from the class of beneficiaries. Now plainly that can't be a power held on behalf of the trustee, that's his own power. And it was one which he was obliged to exercise in the interests of the Karuna Trust. Equally, trustee was not obliged to follow Mr. Stava's instructions in that respect. I accept, 57, that the trustee would not automatically have followed Mr. Stava's wishes in relation to the addition or exclusion of potential beneficiaries, or in making distributions. These were very different contexts to the management of Diag's business. So, of course, when we were looking at Diag's business earlier, it was more straightforward. Essentially, everything's been delegated to Mr. Stava. These are very different contexts. Here, though, while I accept that the settlor, as a settlor and member of the beneficiaries, Mr. Stava would have had a very important voice in these decisions. The trustee would have had regard to all relevant circumstances, including Mr. Stava's wishes as settlor on the source of the assets, the views of members of the beneficiaries, the purpose of the Karuna Trust, of settlement planning, tax consequences, whether there are any creditors, etc.
The reference to a trustee having to be domiciled in Liechtenstein appears to be in paragraph 23, little 2, on page 100. At least one trustee had to be domiciled in Liechtenstein, clause 2.2b.
Yes, indeed.
And if more than one, they were to act by a majority.
Indeed. Your Lordship, beat my learned junior to it.
My lord, that's in the trust deed at SB 48, page 4.
Indeed. Grateful to everyone. Then we have at 58 that Mr. Stava had 3 daughters who were members of the class of beneficiaries themselves and parents of the other members. They supported Mr. Stava's wishes as to membership or the distribution of assets. Sorry, I should rephrase that. Had they supported Mr. Stava's wishes, it is virtually certain that the trustee would have formed the perfectly proper professional judgment that it should act. The point being made here is, had they done that, there was no real prospect of a situation arising where conflict would arise between Mr. Stava and the trustee, disagreement. Then we go on. I accept the evidence of Mr. Stava's daughters that they found it difficult presently to foresee circumstances in which they would have opposed their father's wishes in relation to those 2 issues. So in other words, who's in the beneficiaries class and what about distribution of assets from the Karuna Trust? In my assessment, it is highly unlikely that there would have been any disagreement between Mr. Stava and his daughters had these issues arisen as at January 2012, the relevant date. And then, had it been necessary to do so, I'm satisfied that there is a high likelihood that Mr. Stava's daughters would have supported him if he had decided to exercise his legal power to remove the trustee if it had refused to give effect to his wishes on these issues, and to appoint himself as trustee together with a Liechtenstein trustee. And of course, given our earlier conversation, or you could just have a Liechtenstein domiciled trustee, a company that he owned. However, I accept Mr. Dunning's KC's submission that it is not fanciful to suppose that there would be circumstances in which there would be a disagreement within the class of beneficiaries as to who the members of the class should be or how assets should be distributed from the Karuna Trust. In that eventuality, it's not possible to determine how the trustee would have acted or whether the trustee could have been removed. So he brings that all together. So all of the, up to there, all of those findings are unchallengeable. Then he brings that together in 61, which is reflected also at paragraph 171 of the judgment. And we can just go through them. Mr. Stava had made an investment in Diag. 2, no investment was made by the Karuna Trust or the trustee. Law book transaction was not a genuine arm's length transaction, but an attempt to create apparent distance between Mr. Stava and Diag. Following the indications from high levels within the Czech government that this would be helpful to attempt to resolve the dispute by negotiation. 4, his legal decision-making powers as chairman of Diag, holder of the bearer shares, and protector were not, in the first 2 instances, held in his own right. So recognising, therefore, that his legal decision-making powers as protector were, and in each case, so all 3 of those, were not exercisable solely by reference to his own interests, but only in what he believed to be the best interests of Diag or the Karuna Trust as appropriate. And of course, an important point, that was also true of the trustee's powers. This goes to the issue of where a right or power is fettered, that somehow undermines an assertion that control derives from it. And it's a point made against us that such powers as Mr. Stava held in his own right were powers which were fettered or qualified in some way. But of course, what arises from this is the very person that the Czech Republic says, if there is de facto control, holds that de facto control, namely the trustee, also has qualifications or fetters on their ability to exercise their powers. 5, there was no realistic possibility of a conflict of interest between Mr. Stava's own interests and those of the Karuna Trust in relation to the conduct of Diag's only business. The trustee was entitled to and did leave those enforcement efforts to Mr. Stava, also funded them. 6, no realistic possibility of the trustee or any other members of the class of beneficiaries disagreeing with or seeking to challenge any decision taken by Mr. Stava in the conduct of Diag's business. The trustee had the legal right to sell the shares, where he formed the good faith view that such sale was in the business interests of the Karuna Trust and a prudent business judgment, but it was virtually inconceivable that it would have followed such a course if Mr. Stava had opposed it. Had the trustee been intent on pursuing such a sale in defiance of Mr. Stava's wishes, I'm satisfied that the daughters would have supported Mr. Stava in removing the trustee in the exercise of his powers as protector and or appointing himself as trustee together with a Liechtenstein domiciled trustee. I make the same point again. Could have just been a Liechtenstein domiciled trustee, and that Mr. Stava would have been able to act so as to prevent a sale which he opposed, consistent with his duty as protector. And then over the page, he had the legal power to prevent the trustee changing the class of beneficiaries to be exercised in what he believed to be the best interest of the trust. And then as settlor and the beneficiary, he had significant influence over decisions by the trustee to add or exclude beneficiaries, but he had no legal right to require the trustee to act in a certain way. But the trustee wouldn't automatically have followed those wishes. In the circumstances in January 2012, Mr. Stava's 3 daughters would have supported his wishes as to the class of beneficiaries, membership, or the distribution of assets. And in those circumstances, it's virtually certain that the trustee would have formed the perfectly proper professional judgment that it should so act. Had he refused, a high likelihood that Mr. Stava's daughters would have supported him if he decided to remove the trustee and appoint himself together with the Liechtenstein trustee. It's not fanciful to suppose, this is the final point again in the annex, that there might be a disagreement in circumstances in which there would be a disagreement as to how assets should be distributed. In that eventuality, it's not possible to determine how the trustee would have acted. So, one point here, this was the mix-up on the daughters, because of course we've seen reference to daughters. There is a point to make about the daughters in our additional ground under Respondent's Notice, ground B. We've always said that Mr. Stava's control was subject to his daughter's consent in respect of his powers as protector. And the Czech Republic said in its pleading, well, that didn't amount to control for the purposes of the treaty. It's been found against them, held against them that it did. What they could have said in the alternative, but never did, was even if, with the daughter's consent, that would have provided control, that was not control of a Swiss national, because the daughters might not be Swiss, an issue as to Swissness of the daughters. And so alive to this possible fallback for the Czech Republic, Dagmar Stava's witness statement for trial set out that all the daughters were Swiss. We don't need to go there, but the reference is paragraph 7 of her first witness statement for trial.
The judge found they were Swiss.
Yes, but he says, yes, that's right.
He said,
But he says-
I don't rely on that.
Exactly.
But he found they were Swiss.
Exactly. So he found they're Swiss, but the point that is, and we rely on that in our respondent's notice to say that's an additional ground, insofar as it is said against us. Mr. Stava's control was not Swiss enough for the purpose of satisfying the treaty, because it relies on other people's consent to certain steps to effect that control. Our point is, well, that consent, the holders of that consent, the people who exercise those powers, were also Swiss, as the judge found. Now, said against us, that's not open, that's not a point that's open to you to make. You didn't raise it at the trial. It's right, it wasn't a pleaded point, but the point, the issue as to whether they were Swiss was certainly in play at trial. The Czech Republic now says, oh, well, if we'd known that this was an issue, we would have cross-examined the daughters about their nationality. There might have been points that we could have made about dominant and effective nationality and so on. We don't concede that those are relevant considerations in that respect, but they say we would have taken a different approach. Our answer to that is no, these points were in play. It was in the evidence. We also addressed the Swissness of the daughters in our skeleton, the trial at paragraphs 155.5, 158, 161.3, that's SB 32, 62 to 64. So we simply say, insofar as it is said that Mr. Stava's rights were qualified by the need to look to other people's consent to enable him to exercise control pursuant to those rights, that was also Swiss, and for that reason, Diag, in that alternative, also satisfies the test. So I set that out to meet the response to our respondent's notice. Now, having looked at the annex, was there de facto control here? It may be helpful for the analysis to have the table that we handed up to the judge at trial before you. That is it's in the hard copy bundle, SB 43. So we produced this at trial for the judge as a handy aid memoir to help him in identifying rights, powers of control, and where Mr. Stava and other Swiss nationals appeared in that structure. Just to sort of orient this, in the middle you see the trustee. Above you have settlor and protector. Below you have legal right to exercise voting rights, and then the last two are Diag specific, Diag management specific points, company management, and then operational control. Essentially, above the trustee, those are powers and rights that Mr. Stava exercises in his own right. They're not held on behalf of anyone else. Off to the side, as a beneficiary again, rights not on behalf of anyone else. Then under the trustee and down, they are rights on behalf of others, either of the trustee or of Diag. And then again, off to the side towards the bottom, you've got the fact that he's a founder and the provision of finance, taking the financial risk. So essentially just running through that table and assessing what control Mr. Stava had and what rights and powers he had. As the settlor, Mr. Stava had the influence that came from the trustee having to have regard to his wishes as to the membership of the beneficiary class, and that was exercised in his own right. And the reference back to that is Annex 3 in terms of the findings. Annex 3, paragraphs 57 and 61(9). Then we go down to the protector, and this is one of the key ones. As protector, he had powers in his own right, if he considered it in the best interest of the trust, to do a number of things. He could block the trustee in respect of membership of the beneficiary class, so adding or removing beneficiaries. And he could express his wishes in that respect, to which wishes the trustee had to have regard. He could remove the trustee if he obtained the consent of 2 daughters. He could replace the trustee with himself or a company controlled by him if he obtained the consent of 2 of his daughters. And he could thereby procure distributions to himself if he was the only beneficiary and there were 2 trustees. And he could procure changes to the class of beneficiaries if he obtains the consent of 2 daughters. And then, just pulling together the points that the judge made, the findings the judge made in the last few paragraphs of the annex, he found that if the trustee was seeking to sell the shares in Diag in defiance of Mr. Stava's wishes, his daughters would have provided him with the necessary consent to remove the trustee and would have provided him with the necessary consent to appoint himself as trustee alongside a new Liechtenstein domiciled trustee, and that's Annex 355. And he also found that as at January 2012, if the trustee had refused to follow his wishes, it is highly likely that the daughters would have consented to Mr. Stava removing the trustee and appointing himself or a Liechtenstein domiciled trustee. And again, that's Annex 359. Now, in its skeleton at trial, the Czech Republic accepted this as an option to obtain the shares in the future. And they made that point against us as part of their control versus controlled argument, which it seems they don't advance any longer. But that acknowledgement is, we say, sufficient for the purposes of control under the treaty test. In other words, if you've got the power to obtain the shares in the future, that gives you control for the purposes of the treaty. And the reference to that in their skeleton at trial is in their revised section E, paragraph 166F, SB 38, page 35. And I should add that this is, of course, what has now happened. So on the 22nd of May 2024, a deed was signed by which the trustee agreed to transfer the shares to Mr. Stava. And we can turn that up. It's in your hard copy bundle at SB 79. The deed of appointment. And we see deed is made on the 22nd of May. And then it sets out the provisions, relevant provisions of the trust deed. And at D, that Mr. Stava has requested the distribution of shares. Trustee has considered it objectively justified under the particular circumstance of the Krona Trust and the beneficiary in question to appoint him as the sole beneficiary with regard to all 25 bearer shares. And he's consulted with the other current members who have confirmed they have no objection. So all of this is consistent with the findings of Mr. Justice Foxton. And then if we go over the page. Thank you. Oh, sorry, it's because it wasn't there. Can we go back to, I hadn't realised it had cut off. Yeah. Now, this deed witnesseth as follows: the trustee of the Krona Trust, in exercise of the powers conferred on it by clause 6.1 and of all other powers enabling it, hereby appoints Mr. Starver sole beneficiary with regard to all the shares, and 2, said bearer shares shall be distributed and transferred to Mr. Starver by notification and instruction to the custodian, and then signed by the trustee and Mr. Starver. Now, the Czech Republic says it's not open to us to rely on this, which we do in our Respondents notice, point A. We disagree.
Just before you get there,
Yes.
how does this show that de facto control is being exercised if what the trustee is doing is considering a request from Mr. Starver, qua beneficiary, deciding that he will exercise his powers to transfer the bearer shares to him by beneficiary?
And that's the point that the Czech Republic makes against us. It's simply the trustee performing his duties. It doesn't show that Mr. Starver has control. For the purposes of the treaty, in the circumstances of this case, and given the findings of the judge below, that it's virtually inconceivable that the trustee would disagree with Mr. Starver, and also that as regards the conduct of Diag's business, their interests were perfectly aligned. Those factual circumstances, and this is why it's a de facto test, mean that there was never any realistic possibility, and indeed we would go so far as to say he would
If you're right about that, you get that out of the judgment. You don't get anything further out of this deed, do you?
Well-
This is, if you didn't have those findings in the judgment, this would be consistent with a lack of de facto control.
That may be right, my lord.
So what do you get out of this?
It's confirmatory evidence, or it's weight behind our argument. It's said against us, well, you know, you've got these powers, it's an option to exercise, and so on. We say that's good enough, and look, we did it. That's as far as it goes, my lord. Just in terms of can we actually make this point?
But it's not a legal option in that sense at all, is it?
Well, one needs to think through that in a number of steps. So there is no piece of paper that Mr. Starver is holding in that sense. No, there's no legal option in that sense. Does he have the option, given the powers he has as a protector, given the influence he has, given the perfect alignment of interests, to require this? And does he every day have a choice? Do I ask for the shares to be transferred to me or not? Yes,
There
he
is
has an option.
there is no legal sequence of steps that he can put in train which will ensure that he gets the shares, because there will always need to be an independent consideration by the trustee acting on behalf of the trust that what he is asking for is in the interest of the trust. Now, it may be that in practice the trustee is likely to conclude that it is, but that's as high as you can put it, isn't it?
Absolutely, that is the point. That this is why we're in this world, because this, of course, is the alternative argument. In a de jure world, you might be having some argument about is there a piece of paper that I can just stamp, send, and demand?
Well, it was just your usage of the phrase option to obtain shares in the future, which I know you said the other side had
Yes.
used as a weapon against you, but since you said it twice, I thought you might be putting some weight on it, which I hadn't fully understood, but now I see
Your
what
Lordship
the position is.
has it entirely correctly. If they hadn't made the point, I might have simply said, as I will, that through the combination of his various legal powers and the factual circumstances, he's able to procure this. That is the
This
point.
isn't what he's done. I think I understand your main point, at least, on what the judge found, which is that we're focusing on his powers as a protector, which he holds in his own right. That gave him the power to put himself in the position of a trustee or a company, a Liechtenstein company he owned as trustee, who could then have transferred the shares to him qua beneficiary. That isn't sufficient on its own to give him de jure control, which you accept he didn't have, because he could only do that with the consent of two of the daughters. But you couple that with the practical finding of the judge about what
Exactly.
would have happened, and you say that's what gives rise to the option. If I followed the argument so far.
If one describes it as an option, that's what gives him.
That's what gives him the option. Now,
Yeah, that's what gives him de facto control under the treaty.
that isn't what happened here. So why does this help us?
Because it
I can
doesn't.
quite see that if that had happened since, you could say, well, there we are, that's the proof of the pudding, as it were.
Yes.
The judge was right to make the findings he did, although where that would take you, I'm not sure. But since that isn't what happened here, so what?
Maybe it doesn't add anything, my lord. But if it's said against us, well, you know, it was all very complicated. And in fact, I think this is a point that is made against us. A number of steps would have needed to be gone through. We've demonstrated actually it's quite straightforward. So I think it's perhaps safest to see our position, as I will clarify further, as the way your lordship put it, namely legal powers combined with particular factual circumstances, giving you what amounts to de facto control under the treaty. I mean, this merely confirms that this was something he could have done in January 2012, being the relevant date of assessment. He did it in May 2024. We simply say it helps confirm the position as it stood at the relevant date. But I don't want to spend too much time on it. The only point I'm really beyond that making is that it's open to us to make this argument. That document was admitted into the trial bundle at trial. They asserted that it was irrelevant and therefore inadmissible because it was too late. They now accept that subsequent events can be relied on to inform what the position was as at January 2012. That's as far as it goes. Then a third aspect of the protector powers, and based on the judge's finding, is that if in his view, in Mr. Staver's view, it was in the best interest of the trust and a prudent business decision and didn't present a conflict, the protector had the power to remove the trustee and appoint himself trustee with his daughter's consent. And we take that from Annex 3, 32 Roman 1 and Roman 2, and 29 Roman 1 and Roman 3. Now, Mr. Staver could, in those circumstances, therefore have become a trustee alongside a new domiciled trustee, or, as I say, put a Liechtenstein domiciled trustee that he controlled in the place of trustee, regardless of whether there had been a disagreement with the trustee. So for the same reason as the judge found in relation to the other scenarios of replacing the trustee, in particular Mr. Staver's unique connection to Diag, its business and its claims, we submit he would have been able to do this at the relevant date, namely 31st of December, 1st of January 2012.
Can I just, forgive me to interrupt you, can I just see how he would, if he put a Liechtenstein domiciled company as a replacement trustee, how would he have been able to control that company consistently with the company's duties as trustee? What form of control are you envisaging? That he's the sole owner of it?
He could be the sole owner. I should also point out they don't need to be professional trustees. So there's no requirement for it to be a professional trustee. But yes, so he can be the sole owner. Then the person exercising the powers of that, or the trustee performing the trustee duties of that,
Yes.
of that entity. In other words, the person in Dr. Raban's position at the moment
Yes.
would be required to act consistently with the duties of a
Trustee, not in accordance with the wishes of the shareholder if they conflicted.
and of course, this is why we're not in the de jure world and we are in the de facto world, in a world where these factual circumstances exist. That trustee would have followed his wishes.
You've got a finding to that effect?
Well, we have a finding to the effect that the present trustee, it's virtually inconceivable, in fact, that would have followed his wishes, virtually inconceivable that would have disagreed, that the interests were perfectly aligned in respect to the Diag business. So we have a situation there that
That's not,
I think we might be talking across purposes.
that would be sufficient, which wasn't the judge's findings, that there was de facto control simply because he would have been able to influence the trustee to transfer the shares to him if he'd asked for them. But that isn't the basis of the judge's findings, and that's not the basis for practical control. So I'm not quite sure why you can say, well, that's what would have happened if he'd appointed a replacement trustee. So that gets you home.
I mean, the short answer to this is, as I understand their position, it's the Czech Republic's position. They say any de facto control was the trustees. And so all we need to do is show that Mr. Stava could himself or have somebody in that place, and hey presto, that person is the person that the Czech Republic says has control. So they accept, in fact, their cases, and we don't dispute this, that the trustee is subject to duties. Of course they are. But they say that person has control. Undoubtedly, that person has the de jure control. So you tick the box. You've ticked the box in that way to start with.
The point I'm putting to you is that prima facie, that person has the de facto control unless you can show it resides somewhere else. Now, in the replacement trustee world, if you want to show that Mr. Stava would have had de facto control, then don't you have to have some findings about how a replacement trustee would have behaved consistently with that new trustee's duties as a trustee?
I would suggest we have sufficient findings here, because what those findings are findings as to what a compliant trustee, compliant with Liechtenstein law, would do. It's not about Dr. Rabanza personally, it's not about LNR Trust specifically. It's what would a compliant Liechtenstein trustee do. Now that's just as applicable to LNR Trust as it is to a nominee or an appointment or a company controlled by Mr. Stava, i.e. a compliant Liechtenstein trustee would follow Mr. Stava's wishes. It's inconceivable in the circumstances of this case that a compliant Liechtenstein trustee, with regard to the best interest of the beneficiaries, business judgment rule, prudent business, and so on, would act in a way that was contrary to Mr. Stava's wishes.
Well, we know that, in fact, the daughters and Mr. Stava have remained close and aligned. But the judge also finds that it's not fanciful to suppose there could be circumstances in which there is a big family bust-up. And unfortunately, we see that in these courts all the time with some very bitter disputes. And he says if that happened, it's not possible to determine how the trustee would have acted or whether they could have been removed.
Then you're into a world of, well, what's the standard that your lordships and your ladyship need to be satisfied of? Now, there was one case that I believe my own friend Dr. Parlett referred the court to when she was making her submissions, which is a case of Thunderbird, in which supports our position on de facto control. In that, there is an oddity of a requirement for the standard of proof to be beyond reasonable doubt. That's the only one which suggests that that high, and so
Well, as a later award says, that doesn't make very much sense just to shift the standard of proof.
indeed, so on that,
They said it more politely than that.
even if it was beyond reasonable doubt, if we're in a world where we have virtual certainty, high degree of likelihood, or even total certainty in some respects, in respect of the management of the company and the pursuit of its claims, we have those on our side. We would satisfy that for us worst case scenario where we had to prove beyond reasonable doubt.
You say,
I don't think we get there because, in the sense that it's obviously a balance of probabilities.
you say that the only point of time which matters is 2011 stroke beginning of 2012,
Yes.
at which stage the judge has found they hadn't fallen out and they would have supported him.
Yes.
And therefore, the possibility of a falling out
Yes. And in,
doesn't affect whether there was de facto control at that point of time.
exactly. And insofar as there was any question mark, it's the points I just made about you would in any event meet the very high standard, but you would certainly meet a more obvious standard of balanced probabilities. So, sorry, my lord. The point also in respect of the Liechtenstein company is, of course, he could be the sole director, so nobody else has to approve the decisions being made. Now, of course, that's still within the framework of compliance with Liechtenstein law, but as we see, there is no material likelihood that he would not be, that a Liechtenstein company acting in accordance with his wishes would be in breach of Liechtenstein law. So that's where we get. Now, I was just in the middle, my lord, of are your lordships, your ladyship happy if I move on? Just in the middle of explaining this point about, regardless of whether there had been a disagreement with the trustee, Mr. Stava could replace it. The reason, of course, being that his powers as protector entitled him to make decisions, take steps, if he considered that they were in the best interest of the trust, and he would get his daughter's consent. And of course, in the particular circumstances of this case, with his unique position, one could quite see that he would be, it would be in the best interest of the trust if Mr. Stava decided to replace the trustee.
Sorry, forgive me, just before you move on, my mind
Yes.
is working a bit more steadily. But was there any evidence of Liechtenstein law as to whether he could have been appointed as sole director of a Liechtenstein company? Do Liechtenstein companies have to have a Liechtenstein director?
I don't believe there was, my lord. We will check, but I don't believe there was.
So when you say he could have been the sole director of Liechtenstein company, that's assertion rather than something that was covered in the evidence.
Until I find a reference, yes, my lord. Now, this point about replacing the trustee, even when there's not a disagreement, was in play at trial, and it's one of the reasons the judge noted the protector's powers of removal and appointment in the annex that we've looked at. Now, out of an abundance of caution, we raised this particular point, i.e. replacement removal, where there's no disagreement, because the judge made certain findings about disagreement. That was his particular focus at the end, but it was in play, and we raised this in our respondent's notice as an additional ground at ground C, although we didn't need to. It's now said against us that the point was not in play at trial. I'm afraid that's simply not correct. What I'll do is just give you some references. I won't take you there, given the interest of time. But I referred to it in my opening on day 2 of the second hearing, which is transcript, page 39, line 16, to page 42, line 18, and the reference is SB 34, 11 to 12. And there I pointed out that the debate about distribution was a red herring, because Mr. Stava could, regardless of any intent to effect a distribution, simply replace the trustee, and he could therefore become trustee himself or appoint a Liechtenstein domiciled trustee. I made the very point that it is now said we did not raise. I also cross-examined the Czech Republic's Liechtenstein law expert on this, and the reference is day 5, page 75, line 6, to page 80, line 14, and that's SB 37, 20 to 21. And then I addressed this specific point, i.e. removal, replacement of trustee, disaggregated from any intent to distribute. I made this specific point in closing, and that's day 8, transcript, page 160, line 23 to page 161, line 7, and that's SB 42, SB tab 42, page 41 to 42. Now, the judge's findings, so these are the findings on replacement, removal of trustee, distributions, and ability to remove the trustee in the absence of the distribution question, accord, we submit, with the position under Liechtenstein law, and that is that a protector may have powers of control over a trust. Now, given time, I'm not going to take your lordships to it, but I would refer you to Schopper and Valk in trust companies and special asset dedication, and that's paragraph 760 to 761, and that's at SB 65, page 5, where it was said, a reference was made to a princely court judgment that recognised that the protector is generally understood as a monitoring body which is intended to mediate between the trustee and the beneficiaries to control the trustee. Now, just a comment about English law. It may be tempting to think about the question of any tension between de facto control within the meaning of 11C under the treaty and the validity of the trust through the eyes of an English trust lawyer. But as I touched on in my opening earlier on, before Dr. Parlett made her submissions, we submit you should exercise great care when considering any English trusts or common law trust cases, because insofar as domestic law is relevant, then of course the issue here is not one of English or common law trust. It's a substantive issue of Liechtenstein law, and whilst Liechtenstein law trusts have some ancestry in English trust law, they are fundamentally different. We cited in our skeleton at 58, we don't need to go there, the comment of Lord Hodge in Perry and Lopag that Liechtenstein trust law is not closely modelled on English law, and we noted that even English cases recognise the power of control that a protector may have in foreign law trusts, and that was Independent Trustee and Noble, and the reference there, we don't need to go there, is Core Bundle 20, page 32. And one of the distinct differences between English trust law and Liechtenstein law is the enhanced control which a settler of a trust, such as Mr. Stava, can exercise, in particular by appointing someone to be the office of protector. And it's one of the reasons why people choose Liechtenstein law over other systems. And that principle of control by a protector was before the judge. That was in Schopper and Walsh. He had that reference, and that referred also to the Princely Court decision, which your lordships can also find. Again, we don't need to go there, at SB 57, which refers to a protector as being a supervisory body and a controlling and mediating body. So that's all within the framework of legal rights as protector. We'll move more quickly now. Legal rights as beneficiary, we now move on to. As the beneficiary, Mr. Stava held certain rights on his own behalf. The judge found that the beneficiary had the right to demand the trustee faithfully execute the terms of the trust and diligently execute the business. That's in Annex 3 at 29 Roman 9. There was, in the particular facts of this case, only one business, which was the pursuit of Diag's claims. And as regards that business, the judge found that Mr. Stava's interests and the trust interests were perfectly aligned, and there was no meaningful possibility of the trustee disagreeing with Mr. Stava's views as to how to conduct the business. And that's Annex paragraphs 45 to 47. So on the facts of this case, and of course it's a de facto assessment, As beneficiary, Mr. Stava had the right to demand the trustee diligently execute the business in accordance with his wishes. That's as beneficiary. Then we have now on the table, the Swiss law table, you'll recall we're now moving below the trustee. He was the holder of the bearer shares, and he had the legal right to exercise the votes of the shares in Diag, and that was on behalf of the trust. But given the particular facts of this case, including the absence of any real scope for conflict between Mr. Stava, Diag, and the Karuna Trust, he was the determinant voice in Diag, and that's Annex paragraphs 51 to 52. Now, I should just say it here on the table, you'll note legal right to exercise voting right. In the wording underneath that, we say he had a complete discretion to exercise the voting rights in the best interest. We clarified to the judge at the trial that the wording complete discretion meant that Mr. Stava was able to decide what was in the best interest of the trust. And on the facts of this case, where there was a complete alignment of interest and the trustee deferred to Mr. Stava, the reality was that Mr. Stava could vote as he saw fit in the best interest of the trust. Then, so that was legal right to exercise the votes. Then there was the influence over the board, which arose the finding that was made in Annex 3, paragraph 30, paragraph 51. That was the point that Mr. Stava, in his own capacity, could influence 2 of the 3 other board members. Then there's the fact that he point about his role as a decision maker in Diag and his operational control. Those were powers exercised for Diag, on behalf of Diag, but the trustee deferred to Mr. Stava on all decisions. And then we have his expertise, his ability to lend his expertise by giving witness evidence, for example, to assist in the pursuit of claims, was something that was uniquely within his power. It was not something that was exercised on behalf of others. And similarly, as the funder of Diag, it was entirely in his own capacity that Mr. Stava could decide whether or not to fund Diag and its pursuit of the claims. And that's Annex 3, 47. So, concluding that analysis, we've set out at length the aspects of control at paragraph 45 of our skeleton. We don't need to go there at the moment. But what is clear, I'd submit from my analysis, is that Mr. Stava did hold rights and powers and influence, which were all aspects of his de facto control. And importantly, while some were held on behalf of others, other rights and powers and other aspects of influence from which he derived significant control were held in his own right. And that's all based on the judge's findings. So, taking stock, it seems to us that there were 3, possibly 4 types of control. One, or the first aspect or type, were legal rights and powers which Mr. Stava held in his own right, which did not give legal control of Diag on their own, but which, in particular factual circumstances, could be exercised by Mr. Stava to give him de facto control of Diag. Those particular factual circumstances were found by the judge to exist. And these included, this category included his powers and rights as protector in particular, but also, though we don't need them to make our case good, as settlor and beneficiary. Then, second type, or second category, the legal rights and powers exercised on behalf of others, which in particular factual circumstances would give Mr. Stava control. Again, those particular factual circumstances were found by the judge to exist. And these included his powers and rights as holder of the bearer shares and the person authorised to vote on the shares held on behalf of the trustee, and his powers as chairman and sole signatory held on behalf of Diag.
If their rights being exercised on behalf of others, how do they come within the concept of control within 11C?
Because of this disjunct. One is not looking at this for the or I'll put it another way. We are seeking to address the application of the test under the treaty to the facts of the case. Now, some of the facts of the case are the relevant positions as a matter of the domestic law. And you look at that and you assess that in its factual context. What was the effect of that particular legal relationship in the factual circumstances of this case? What does that mean down there in Liechtenstein for, at the international level, for the question of whether, under Article 11C of this treaty, Mr. Stava had control of this company? One needs to sort of get up into the clouds above Liechtenstein, which I think is somewhere between Switzerland and the Czech Republic, and ask, well, what's the control situation at this international plane?
Yes, on that plane, there are plainly people who have de facto control over assets who wouldn't come within 11C. Barclays Asset Management, say, who are managing a portfolio of shares. You wouldn't treat them as the person having control for the purposes of 11C because they're doing so on behalf of others. Now, what is it about these legal rights which, if they are being exercised on behalf of others, distinguishes them from any other legal rights which are being exercised on behalf of others?
So
at the international plane,
on
what's
their
meant
own,
by control?
sorry, my lord, I interrupted. Yeah. On their own, just looking at these, right, it's the argument about, it's the fact that when these rights are exercised, being exercised on behalf of others, the others defer entirely to the person exercising those rights, and thus that person is able, as I said just in respect of the point about the complete discretion, that person is able to exercise those rights as they wish. Now that as they wish is not something that you find in the legal framework. That as they wish derives from the factual circumstances.
Same is true of Barclays Asset Management in the example I gave, isn't it?
Well, if particular examples align entirely, then that may satisfy the test. I mean, it does all depend on the circumstances. Now that was my first point. The second point is, of course, that we have always maintained that this is a cumulative analysis. One looks at the package. One says, what are his rights on his own behalf, protector, etc. What rights is he exercising in effect, pursuant to his own wishes, but legally on behalf of others? What are the rights beyond that he has in respect of the management of the companies? What other aspects of influence and power does he hold? One has to look at this as a whole. And so one can always, of course, pose examples and say, well, what about that? What about this? And this is the approach that one has to take under the treaty. One looks at the factual circumstances and one asks whether at the international level, on the international plane, this person is someone who is entitled to treaty protection. And I mean, just on that, it's because what one is doing here potentially is slipping slightly into questions of treaty interpretation. And I might just make this point. The analysis that I'm setting out here, i.e. that when one looks at the full picture, which includes legal rights, but also the factual circumstances, it not only gives us the answer on the de facto assessment, it also assists on the treaty interpretation link. Because what my learned friends are asking you to do is to interpret Article 11C as meaning that even where there is an entity whose determinant voice, and those are the words of the judge, guiding hand and financial force, is a national of a contracting state, you are nevertheless required to conclude that that entity is not entitled to treaty protection. And in our submission, you only have to state that to realise that it's absurdity. That the Czech Republic and Switzerland wanted to encourage investment in each other's territory by protecting investors of the other. And indeed, at the time of the conclusion, the Czech Republic is, of course, or Czechoslovakia was emerging from communism, and so would have been particularly keen to attract investment from wealthy Swiss nationals. Now, to do so, it does have to reassure the widest category of natural and legal persons, and the people who are actually taking the investment decision, to use the word, judge's word, the determinant voices of those entities. So to read this treaty as not covering such an entity, and I'll just repeat that, an entity whose determinant voice, guiding hand and financial force is a national of a contracting state, read the treaty as not covering such an entity only because one narrow possible route to showing control is not present, namely the existence of a legal instrument or instruments providing for control over the votes, that's my learned friend's case, would, we say, not only ignore the ordinary meaning of control, but it would run directly counter to that economic purpose, encouraging investment. So we say it makes no sense on any principled approach to treaty interpretation and should be rejected. So,
sorry, I took you out of your way.
No.
But
I
second of your 3 or 4 categories, legal rights exercised on behalf of others.
Yeah. So I'd done those 3 categories, and I think I had I'd done 2. I think had I. Yes, thank you, my lord. So first is in his own right, which, given particular factual circumstances, would give him control. The second was on behalf of others, given particular factual circumstances, would give him control. Effectively, he can exercise those rights held on behalf of others legally, as he wishes factually. Then third, you have other powers and influence that he possessed exclusively in his own right, untrammelled either by the need for particular factual circumstances to exist, that's of course the first category, protector rights and so on, or by an agency relationship, that's the second category, voting rights. And these untrammelled powers include his influence, his ability to fund Diag and its business. He had the power to turn off the tap, and his influence over other board members and his expertise. So those are 3 positive aspects of the powers. There was also, of course, then a negative power, which was in that the trustee, and that's the person who, according to the Czech Republic, had de facto control, could not sell the asset of the trust or take any significant business decisions without Mr. Staver's consent. And if he tried to do so, or indeed do anything that Mr. Staver did not agree with, Mr. Staver could have removed him and replaced him with himself or a Liechtenstein domiciled trustee. And as I say, emphasise it again, we rely on the cumulative effect of those matters. I've also made my point about treaty interpretation, that to read it in a way that that person, that entity, where the determinant voice is a qualifying national, where that entity does not qualify, it would run directly counter to the purpose of the treaty. So now, relatively swiftly, I hope, I can actually turn to conclude by going back to where I started, which was looking at the 3 points that the Czech Republic makes on its appeal. And we can, if we could turn back to their skeleton at paragraph 56, that's core bundle, tab 18, page 20. And you'll recall I took your lordships and your ladyship to this yesterday. Paragraph 56, bottom of the page. We have A, B, and C. And I'm just going to run through them in order. So A, their point there is any interpretation which takes account of de facto control only does so on the basis that a legal right or proprietary interest is necessary, but in some circumstances insufficient, such that Diag still fails the test. So this point arises in the world where you have held that control under Article 11C is broader than the narrow de jure meaning that the Czech Republic seeks to give. So this is their first argument on their alternative case. So they've lost on their de jure argument under treaty interpretation. And they say that in that world, even if you can take de facto control into account, you still need a legal right or proprietary interest of some sort. Now, my learned friend said nothing at all on this in his submissions on de facto assessment on Wednesday. He restructured his submissions so that it was just B for about 99% of his submissions, and then he addressed C for about 30 seconds, saying, well, I'll wait to hear what Mr. Richards says. So A seems to have dropped away entirely, and one can see why, because Mr. Stava obviously satisfied that requirement. He had legal rights. There can be no dispute that he had certain legal rights. They were found, which can be found in legal instruments, valid in Liechtenstein law, including the very trust deed that we are looking at, his powers as protector and beneficiary set out there. In particular, we would rely on his rights as a protector. When combined with the particular circumstances of this case, the de facto aspect, he held the determinant voice in Diag and could control it directly and through the trust structure. So on the Czech Republic's own case, we would say, on this head, Mr. Stava plainly had control. Now, again, it's said against us that we've not raised this point before. Out of an abundance of caution, this appeared in the idea that he has a legal right in any event, even if it's not, doesn't provide him with a de jure, doesn't satisfy the de jure test under the treaty. We say he has a legal right anyway. They say you can't raise this. This was in our respondent's notice at point D. It has always been our case that the right to vote the shares was a legal right, and indeed that Mr. Stava held a number of other rights, his rights as protector. Indeed, that's why the Czech Republic addressed those points at trial, denying that they were rights that would go to assessing control and denying that they were rights that would give him control, whether because they were held on behalf of someone else or for other reasons. So there's no reason for saying we're not permitted to run this point now. So that was our respondent's notice, point D. And we say this aligns with the analysis in von Pessold, which was a case that my learned friend Dr. Barles addressed you on yesterday. The control found to exist in that case was not pursuant to a shareholders' agreement or any other legal right, but was an informal arrangement on the basis of family connections. And although the tribunal, I believe it was my Lord Justice Popplewell, who pointed out that although the tribunal actually described it as legal and factual control, what it found was that the control existed because of the factual realities in that case, namely that the children and the husband voted in the way that Elizabeth directed them to. Why did they do so? They did so because of her influence as the source of the family's wealth, and because the family acknowledged that she was in overall control. So through their shareholding itself, they didn't have sufficient to exercise control other than blocking special resolutions. And that was not, as we say, therefore, through any legal rights. It was purely on a de facto analysis of the family arrangements. And the references, we don't need to go there, to the case at LA 76, page 84, and I would ask your lordships and your ladyship to look at paragraph 221 and 226 in particular. Similarly, the only other comment on the Czech Republic's arguments on this ground A is in respect of their reference to and criticism of paragraph 210 of the judgment. Your lordships and your ladyship may remember this, where it's right at the end of its assessment of the cases, page 63 of CB 23, page 63 at the bottom. He then turns to assess gramercy, and he notes that they talk about ownership being required, but then at 1, 2, 3 and 4, he addresses what they in fact consider to be ownership. It's essentially a functional analysis of ownership, namely, in shorthand, who carries the business risk. Now, the criticism of the judge's assessment here, first off, this was an authority that in fact the Czech Republic took the judge to, so they can hardly criticise him for referring to it and analysing it. Secondly, he quite rightly took note of the way that the tribunal there applied that functional analysis to the word ownership and considered what the attributes of that status were. And they, the tribunal, and he, the judge, concluded that ownership had particular economic attributes, including assuming the business risk, funding, investment, and so on. And the judge below found that on the facts of our case, it was Mr. Stava, and certainly not the trustee, who bore the business risk. And the relevant references, just for the transcript, are LA, well, I'll give you the paragraphs first. Paragraph 583, 615, and 658. And the bundle references are LA, tab 89, pages 128, 133, and 141. And in that case, the relevant person had made no contribution, no financial contribution, and that was considered to be relevant by the tribunal. And that's very different, obviously, from our situation, where there's no dispute that Mr. Stava is the only source of the funds for the original investment and the only source of the funds for funding the only business of Diag Human now, namely the pursuit of its claims. Third point, even in gramercy, interestingly, one sees the acknowledgement that control might be exercised by something other than ownership, in other words, other than a pure de jure route or test. And that was at paragraph 628, where the tribunal said a corporation is controlled by an investor when the investor, through his majority or minority ownership interest, and or by other means, and those are the words we stress, is able to determine the corporate decisions. And we say that is exactly our situation here. Mr. Stava is wholly able to determine corporate decisions by other means, through a combination of the powers and rights he has under the deed and the factual realities of the case. And the judge in Annex 3, as we've seen, made unchallengeable findings to that effect. So that's point A. If we could just turn back to the skeleton argument at CD 18, page 20. B, this is the second part of the case that the Czech Republic runs on this limb of its appeal. Any analysis of factual control requires an assessment of the legal attribution of the putative controller's conduct, and here any control by Mr. Stava was not in his own right and is probably regarded as trustee's control. In short, Mr. Stava was an agent, and that means it's not his control for the purposes of the de facto test. I would submit there is nothing left to this. Only some of the rights were held on behalf of others. Other very significant ones were held in his own right, and in certain circumstances that the judge found to exist, gave him control. Second, insofar as rights were held on behalf of others, Diag and the trustee, the particular factual circumstances meant the right was one that Mr. Stava could effectively exercise as he saw fit to the benefit of himself and his family. He called the shots. That was a point, my Lord Justice Popplewell, you and I just discussed about 15 minutes ago. And if Mr. Stava considered that Diag needed to take a certain step, the particular facts of this case meant that there was no one who would in fact disagree with him. A couple of nuanced points on this element B, that of managerial dependency. We say that the point I've just made is also an answer to the Czech Republic's criticism of the judge's finding that the trustee in this case, the de jure controller, was necessarily dependent on the de facto controller, Mr. Stava, and that Mr. Stava was the driving force and in charge. Now, those findings are not open to challenge. As the findings in Annex 3 demonstrate, there is no inconsistency between recognising the formal agent relationship on the one hand, and on the other, acknowledging on the facts of this case that Mr. Stava was the determinant voice and thus in control. And so we would say that the Czech Republic's M&A deal example is entirely divorced from the facts of this case. It's a completely different situation. One other nuance, they talk about or address the judge's conclusion that Mr. Stava's influence fell short of practical control in the judgment at paragraph 217. They say, given that finding, it wasn't open to him in law then to find, for the purposes of the treaty, that Mr. Stava was in, or did have de facto control. But the answer to that is that Mr. Stava did ultimately call the shots. The point on this part of their appeal that they're making is, well, his control was fettered. But the judge quite rightly notes, and in fact, when the Czech Republic addresses this in their skeleton, they don't quote the full analysis that the judge sets out at paragraph 217. The judge noted at 217 that those with a majority ownership, i.e. those in a de jure control position, or control of a legal entity, they may find their ability to distribute the proceeds of its activities curtailed for any number of reasons: contractual commitments, legal obligations arising from the interests of creditors, presence of minority preference shares. Indeed, on the Czech Republic's case, the person, well, indeed, on both parties' case, the person with de jure control in this situation, the trustee, that person, of course, has their rights and their powers fettered. There are all kinds of qualifications to them. So it's no answer to the judge's finding that Mr. Stava's control fell short of practical control in that sense, to say, well, then that can't be control for the purposes of the treaty. They also point to the fact that Mr. Stava's evidence is that he transferred the economic benefits of the shares to the Corona Trust. Yes, that's what he said, but it was not a gift of the economic benefits to the trustee. It's a gift of the economic benefits to the discretionary beneficiaries, of which he was one and his daughters were others. And in circumstances, of course, where that's within a framework, as the judge has found, that the trust structure meant that he was the one who ultimately called the shots. Then the final point, are we still on their skeleton? Yes, we are. C, whether analysed under Liechtenstein law, international law, or, sorry, I've just gone a bit quick, I think. Could we have the full page? Anyway, I can read it from the hard copy. Whether analysed under Liechtenstein law, international law, or English law, having taken the position that the Corona Trust is valid and effective, the respondents cannot here take the inconsistent stance that the ex facie position can be contradicted by factual control outside of that framework. Now, I addressed this in my opening before Dr. Parlett spoke yesterday. This is their best of both worlds point. And as I said yesterday, there is no inconsistency. And I would submit it's all the clearer having conducted the analysis we have, going through the annex and then drawing the threads together. There is no inconsistency at all in a determination of Mr. Starver holding the de facto control for the purposes of the treaty on the one hand and Liechtenstein law on the other. The particular facts of this case meant that Mr. Starver did, in compliance with Liechtenstein law, call the shots in respect of the trust and in respect of its asset, Diag Human, and in respect of that asset's only business, the pursuit of the claims.
Well, you've put your case on control within the framework of the trust as a valid and effective trust. Those are the submissions you've made.
Exactly.
So you're not inviting us to say that that was a pretend arrangement or anything like that.
No. So first point really is this doesn't arise. C does not arise. If the point being made is that we are saying that there is an arrangement that is somehow outside this trust framework, then the point doesn't arise because we don't say that. If they are saying, well, the reality of your submissions is that that's what you're saying, even though you don't say that's what you're saying, this is my answer. So it's that they're slightly unclear as to whether they're saying, well, this only arises if you concede that that's the case, or on analysis of your Diag Human and Joseph Starver submissions, that is what you're saying. That's not what we're saying. Annex 3 makes very clear that our position is entirely consistent with Liechtenstein law. And furthermore, there is no principle of Liechtenstein law that has been identified by the Czech Republic as being offended. And I would submit that my analysis demonstrates that there was or is none. There was a valid and effective trust, and within that trust structure, in the particular circumstances of this case, Mr. Starver exercised control within the meaning of the treaty. I don't need to address you on inconsistency with international law, because if it's not inconsistent with Liechtenstein law, then there's no basis for saying that it's inconsistent with international law. They don't identify what principled basis there is in English law for saying that there's that we're somehow acting in bad faith or contrary to good faith. They don't identify any principle, and English law could only be relevant as the law of the seat of the arbitration, and that in no sense could go to interpretation of the treaty. If they're saying there's some kind of abusive process, on my analysis, English law would look to Liechtenstein law to see what the reality was, what is the position as a matter of Liechtenstein law. The findings that the judge has set out in Annex 3 demonstrate that the facts are perfectly consistent with the finding of de facto control. English law would therefore conclude that there is no abuse. So it's difficult to see exactly what they're saying, but that's one way of potentially analysing it. And English law might also look to the treaty and the application of the test, and whether that leads to some impermissible inconsistency. As the judge held, it doesn't. And in any event, there's no room here for the application of English trust law. That's the end of their point C. Okay, thank you. My lord, my lady, might I just take 1 minute? The only point I'll just make this one point, just in terms of assisting your lordships and your ladyship. I've addressed you during the course of my submissions on the points arising out of our respondents' notice at the places where they logically arose. What I've tried to do, I hope successfully, is each time I've done that, say respondents' notice and identify A to E, so that hopefully a search of the transcript ought to bring that up quite easily. If I might just take 1 minute, my lords, my ladies,
Yes.
to see what this point is. So, very short submission on the point that my Lord Justice Popplewell raised about if there was any evidence about who can be a director of a Liechtenstein company. There is no evidence of who can be a director in Liechtenstein, but if he was 100% shareholder of the trustee, he could obviously direct it to do anything that any trustee could lawfully do. Or he can always become the trustee himself if he got domicile in Liechtenstein. And there's, of course, the distinction between domicile in Liechtenstein and nationality.
The judge doesn't seem to have contemplated that as a realistic possibility because it's always phrased in terms of himself as trustee and
Yeah,
a Liechtenstein
exactly.
domiciled trustee. So in terms of the factual findings from the judge, what the contemplated means through exercising protective rights, which the judge contemplated, was dual trusteeship with a Liechtenstein domiciled trustee.
Yes.
Is that fair?
That's fair on the findings of Annex 3, indeed. I mean, the other alternative is that he becomes a trustee with his daughter and outside Liechtenstein. Yes, I'm not sure I actually need to make that point, but yeah. But so that leaves nothing else for me than to respectfully urge your lordships and your ladyship to dismiss the Czech Republic appeal on control. And unless I can be of further assistance, that concludes my submissions.
Thank you very much. Sebastian, it's you next, is it?
My lord, my lady, I shall reply on the first appeal, Mr. Dunning on the second. I start first with the formulation of the objection that it is common ground is live, subject to the argument about it being jurisdictional. This is the post-dating breaches objection. With respect to my learned friend's reasoning, and indeed the judges below, I suggest is flawed. We all remember, of course, that Article 9 covers disputes with respect to investments. The learned friend, in essence, says, that's that. This is a dispute with respect to an investment, because it's a dispute about when Mr. Starver lost title to that investment. But in my submission, that is not a proper interpretation of the language of Article 9, especially when it's read together with Article 2. Now, one can step back from our case for a moment and consider a case where a claimant says, I acquired 2 assets, both of them are investments. And the respondent says, those assets are not protected investments under the treaty. No one suggests that that is not a jurisdictional point. It plainly is. We've just had a trial about exactly that jurisdictional objection. And there's no suggestion that in respect of that type of objection, a tribunal can decide it without the court having power to review. The question of whether a claimant ever had an investment is a jurisdictional fact that has to be established. And if it's not, there is no offer to arbitrate that is capable of acceptance. And so the straightforward point I respectfully submit that the Czech Republic is taking in this appeal is that when a claimant has disposed of an asset, there is not a claim with respect to an investment from that time on. The objection is still related to the investment question, which is a quintessential jurisdictional issue. And that, for the purpose of this appeal, what this court is considering, is ultimately the determinative point. It is properly characterised as jurisdictional.
You say that the question whether a claimant ever had an investment is a jurisdictional fact, but that's not the question in this case, is it? Because the only investment we're talking about are Mr. Starver's investments, which were found to be investments, and whether he ceased to hold them as a result of events in 2011.
So, my lord, the issue in this case, I do accept and I submit, is a variant or a variation on the classic objection in investment arbitration of whether there has been an investment, whether there is an investment, was an investment. And so what we have here,
The variant is something completely different. The once you've established there's an investment, then the next question is there a dispute about it? Answer, yes, there is. That's a substantive matter, not a jurisdictional one.
with respect, my lady, that is where the parties divide.
I know.
And the Czech Republic's, in the Czech Republic's position, is that it would not be correct to say that, well, the objection is that he doesn't have an investment. And so deciding whether he does or doesn't must be a dispute with respect to an investment that is solely for the tribunal to decide. If that were correct, it would also be correct for when a respondent argues that there was no investment at all, that would not be a jurisdictional objection. Ultimately, the...
Chalk and cheese, Mr. Foxton.
I'm sorry, my lady.
Chalk and cheese.
With respect, my lady, we would not agree that they are chalk and cheese. And the reason for that is that ultimately they are both objections that come down to the quintessential jurisdictional issue in investment arbitration of an investment. What one cannot do, in my respectful submission, is divorce all the different variations of objection relating to investment that I have covered in the case law, some temporal, some others, except that they are going to substantive jurisdiction in the Section 30 sense, and then pick out the one variation that my learned friends urge on the court in this appeal, and say that is not a substantive jurisdiction objection, even though it relates to an investment. This comes back to the point that I made, I believe, on Tuesday, about that ultimately being an island of admissibility surrounded by objections going to jurisdiction. I took the court to a good number of cases, the Azerbaijan case before the ICJ, the Tatnev case by Mr. Justice Butcher, and Alcor, Phoenix, and Vuklinghausen awards in front of investment tribunals, all of which dealt with very closely related objections that go to investment and were characterized as jurisdictional. In my respectful submission, the small variation that the defendants urge on this court in relation to the objection that is agreed to be live before this court is not sufficiently different from all of those others to say that's a matter of admissibility only. Indeed, I say that that is the error in my learned friend's case. One cannot accept, on the one hand, that an objection to the existence of a qualifying investment is jurisdictional, which they do, but then say that the present objection in this appeal, also to the existence of a qualifying investment, albeit at a certain time, is not jurisdictional. Whether an investment exists is jurisdictional, and so too must be whether an investment no longer exists. Indeed, if I can just elaborate on Tatnev that I mentioned for a moment, there was an investment, and the question was whether the claimant had acquired it only after the breaches relied upon. Mr. Justice Butcher treated that as jurisdictional, even though it was a dispute with respect to an investment, as her ladyship's question indicated. Now, my learned friend did seek to distinguish Tatnev, suggesting that the focus of the reasoning was about whether there was a dispute that was pre-existing the investment or some other form of pre-existing dispute. And when one reads the paragraph that my learned friend went to, which is paragraph 87 in the judgment, in the context of the preceding paragraphs, particularly 84 to 86, the issue is whether the investment had been acquired by the dates of the breaches, with the conclusion of his lordship being that the offer to arbitrate is only regarding disputes where investment had been acquired at the date of the breach. Our objection, I submit, is just the flip side of that same objection that Mr. Justice Butcher held clearly was jurisdictional. And if that is correct, then this objection is jurisdictional. And indeed, that flip side reasoning, the two sides of the same coin, echoes the reasoning that we saw in paragraph 70 of the Phoenix and Czech Republic case that I took the court to. And indeed, I respectfully submit that does make sense. If one stands back, why would states be taken to have agreed a disputes clause which gives the tribunal exclusive jurisdiction to decide one of these points, not reviewable by the court, but then none of the others that we have seen in the cases? When all of these objections relating to an investment are so closely connected and are so similar to one another. In my submission, that outcome, the island of admissibility, as I put it earlier, would not be the correct outcome. I come now to a second point in relation to the treaty that my learned friend relies on. And this is the point dealing with the relationship between Article 9 and Article 2. Indeed, these were the subject of some exchanges between my learned friend and the court, in particular my Lord Justice Popplewell. Now, it is not disputed that Article 2 delineates the scope of the entire treaty. That is the effect of the word applies in the first line of Article 2(1). And as I understand it, it's also not disputed that this includes Article 2 applying to Article 9, which is why my learned friend accepted that a respondent could make a jurisdictional objection based on whether an investment was made after 1950. And that, I submit, must be correct, as a failure to read Article 9 with Article 2 contravenes basic Vienna Convention interpretation principles. Indeed, you heard from Mr. Dunning on the principle of effectiveness, and there's been no answer to that. Applying that rule, and indeed just an interpretation of the ordinary meaning of Article 9 alongside Article 2, means that one must give effect to Article 2, both paragraphs 1 and 2, in their definition of the scope of the entire treaty, including the disputes clause in Article 9. So when one looks at Article 9 and sees the word investment in it, that is a reference to the investments to which the treaty applies. And the scope of the treaty's application is set out in Article 2. And Article 2, which one recalls the judge made no reference to in paragraphs 145 to 147 of his judgment, says two things. First, the treaty applies to investments by investors, which then meet other conditions. I emphasize by. It applies to investments by, i.e. that have a connection to the person who says they are an investor. When that person then alienates the investment, it is no longer an investment by an investor. The assets are then held by someone else. They are no longer investments to which the treaty applies. That is why the substantive protections of this treaty cease for those assets from that point onwards. And likewise, when one sees the word investments in Article 9, from the point in time at which the claimant has parted with those assets, the word investment does not cover them. The second point Article 2 articulates is that the treaty shall not affect the obligations of the Czech Republic with respect to investments that are not within the scope of the treaty. That defines the scope of the entire treaty, including Article 9. And if we are right on that, and the asset ceased to be an asset or an investment by Mr. Stava in 2011, then that investment is not covered by the treaty from that point on, and the treaty cannot produce any obligations to the Czech Republic, including, obviously, in respect of Article 9 and the offer to arbitrate therein. So when one turns to my learned friend's position on Article 2, with respect, I submit it is difficult to follow. Can we please just put up the treaty on the screen, operator, SB tab 22, page 3. Now, my learned friend says the only temporal limit in Article 2.1 is the one connected to January 1950, i.e. there must be an investment made later than that date. I have 2 points here. The first is that my learned friend accepted, when questioned by my Lord Justice Popplewell, that this is a temporal limitation in Article 2.1, and that it applies to the consent to arbitrate. As such, it is now common ground that a jurisdictional limit in Article 2.1 applies, to use the word from the first line, to Article 9. My second point, in further exchanges with the court, my learned friend also accepted, as I understand it, that there is a requirement in Article 2.1 regarding the connection between investor and investment, which is jurisdictional, despite, of course, that then not being expressed in Article 9. Now, that requirement of the connection flows from the language in the first clause of 2.1, the language before the comma. And with respect, that is plainly correct. It is correct to say that investments by investors has a temporal element. There can be no qualifying investment before an investor has made the investment, and equally no qualifying investment after an investor has disposed of the investment. Both of those are temporal limitations resulting from the words of Article 2.1, and both apply to the entire BIT, including Article 9. The result of my learned friend's case, in truth, is that one ignores entirely the need for a connection between investor and investment, based on the clear terms of Article 2.1, and ignores that that inherently contains a temporal element. Indeed, my learned friend said nothing about the word by in Article 2.1, and nothing about how that phrase investment by or of an investor is used throughout the treaty. But that connection is an express requirement in Article 2.1, which is then expressly applied to the treaty as a whole. One cannot just ignore that or set that aside when interpreting the treaty. If one does, as my learned friend urges, one ends up with what I submit is a plainly incorrect result, where a claimant just needs to show it is an investor and needs to show an investment after 1950, but then with no real need to show a connection at all. Now, where my learned friend ended up in those exchanges rather reinforces the point. He ultimately said that one needs, and I quote with respect, to be very careful to distinguish between different kinds of temporal connections. That highlights the correctness of the Czech Republic's case in my submission. It should not require a court to salami slice the different categories of temporal limitation contained in a scope provision like Article 2, to then pick out which slice is jurisdictional and which one admissibility. The question of whether there is a consent to arbitrate is a fundamental question for states parties to a treaty. The ability to review jurisdictional decisions in a court ought to be taken likewise. On what basis, therefore, can it be said that Switzerland and the Czech Republic would have intended the wording in Article 2 or Article 9 to mean some type of objections relating to an investment, for example, that there was one or was made after 1950, or did the claimant ever have a connection with it, are jurisdictional. But then one other objection, the one in this appeal, is not. There was no explanation as to how that would sensibly work for users of arbitration in London. It cannot, with respect, be suggested that a user of treaty arbitration in London would need to distinguish between slight variations of temporal limitations in order to understand when the fundamental right of court review will exist or not. And coming to the end of my points on this issue, I suggest that those problems became evident when my learned friend sought to explain how it would all work. The court may recall, and I quote with respect, my learned friend saying, all of the other scenarios, selling this investment, selling part of the investment, selling it and reacquiring it, all of that is not jurisdictional under this treaty because there are different kinds of temporal limitations that simply don't apply here. Here, the only limitation that the treaty requires for the investment to be protected is that it must be made by the investor after that date, and that's it. Respectfully, that cannot be correct. It is not sufficient for an asset to be protected as an investment under the treaty that it was simply made in the past by a Swiss investor. To qualify as an investment, it must continue to be an investment of a Swiss investor. That is what we say Article 2.1 requires. Indeed, my learned friend's approach gives rise to the position where it would be possible for Mr. Stava to say that treatment of the assets in 2015, say, was a breach of the treaty, even though the investments are no longer his. Indeed, I believe it was suggested that the answer to this may lay in the definition of investor, i.e. the answer of the tribunal could be that he ceased to be an investor by then. That may be one way of approaching it, and that would also lead to the situation where the objection was jurisdictional. But as I've said, it clearly follows from the use of the word by in Article 2.1 that the objection at issue in this appeal is also jurisdictional in the same way. Indeed, it would be odd in my submission if the question of whether an objection is jurisdictional or one of admissibility somehow depended on that distinction between it being pleaded as an investor point or an investment point. In both cases, the substance of the point is still the same. The treaty does not apply to the investment from that date on. That takes me to my next point, to address a related submission by my learned friend and indeed a point from the judge below. It is said against me that one ought not to read into Article 9, a term that is not there. Indeed, my learned friend yesterday suggested that doing so would not be a good faith interpretation. With great respect to my learned friend and the judge below, that's not a good point. For a start, the Czech Republic is not reading in limitations into Article 9. That provision uses the word investment, and when ascertaining the investments captured by it, one turns to Article 2. That's just a basic question of reading Article 9. But on the point of principle, as I've already mentioned, the court has seen those cases that I went to, the Azerbaijan and Armenia judgment, Tatneft, Alcor, Phoenix, Vuklinghurst, and others. It is plain in those cases that jurisdictional limitations are applied to arbitration clauses, even when not reflected in the text of those clauses expressly. Now, I showed you those cases, my lords, my lady, because they applied temporal limitations to the arbitration or compromissory clauses, which were not stated therein. But it also happens with other jurisdictional issues too, including one that we can see on our treaty. Indeed, this treaty, like virtually all of them, has a territorial limitation in it as well. It only applies to investments in the territory of the host state. But the court will, of course, recall that there is no such limitation expressed in Article 9. Can we please, we still have the BIT on the screen. One can see there that if we go back one page, please, operator. One can see there that there is no mention of territory in the definition of investment in Article 1.2. If we go to page 5, please, operator. There is no mention of territory in Article 9, which is the consent to arbitrate. Now, if one stopped there and did not look at any other provision, it would, I respectfully submit, be nonsense to suggest that the offer of arbitration in Article 9 by the Czech Republic extends to disputes with respect to investments not in the Czech Republic. That is plainly a limit on jurisdiction, not admissibility, even though it's not mentioned in Article 9. But of course, in this treaty, one doesn't stop there, because it is stated to be a jurisdictional limit in this BIT. If we go back to page 3, please, operator, we see Article 2.1 refers to the present agreement shall apply to investments in the territory of one contracting party. And it's worth recalling that the judge below, of course, had no difficulty in saying that a territorial objection was jurisdictional. I may not need to take the court there, but the court will recall from reading the August judgment, and particularly at paragraph 110, that the judge recounted how a territorial objection was put in play below, and then held that he was satisfied that it is open to the Czech Republic to take a territorial objection now. But the limits of that objection are those fairly put in play for this hearing in the reply. That was an objection determined as a jurisdictional objection. And his lordship did so when the basis for it being a jurisdictional objection was not in the express terms of Article 9, but instead is found in Article 2.1, as I've shown the court. In that context, with great respect, it is wrong to say that there is any difficulty in reading the disputes clause in Article 9 alongside the other clauses in the treaty that expressly define the jurisdictional limits of the treaty. To the contrary, what one must do is read Articles 2 and 9 together. My lords, my lady, I'm about to come on to another point, but that might be a convenient moment.
Right. How much longer do you think you'll be?
I would hope I would only be half an hour or less, my lord.
Okay, 2 o'clock.
All rise, please.